Our fifth and last case this morning is Ravenet versus Ravenet, and if I mispronounced that, I apologize, and I hope you'll correct me.
Thank you. May it please the court, my name is Kelly Cotting. I am appearing for Mr. Corey Parker, and he represents Louis Ravenet. Respectfully, that's how I will propose to say it. I would ask to reserve 3 minutes, please. This brief, or I think the issues before the court, there's three major issues. They essentially come down to property distribution and the award of attorney's fees. Mr. Ravenet has been asking that both of those things be reversed. From my perspective, I think the three main issues are the valuation of the energy company, which is referred to as Fresnel Holdings, and then the distribution considering adverse inferences with regards to financial marital misconduct, and then the third one is the award of the attorney's fees at the trial level. I would propose to address them in that order, but I'm happy to answer any questions. We would agree with Ms. Ravenet that with regards to the division of property, the standard of review is going to be an abuse of discretion standard. In our opening brief, we had cited Hadley, which requires the trial court to set forth the findings so that this court, can review them on appeal. In going through some of those factual findings, there was ambiguity with regards to how this energy company was valued. So specifically, finding of fact number 13, the trial court says the wife is valuing the company at $75 million. The husband is valuing the company at $150,000. Obviously, under Sedlock, the trial court has the discretion to award any value in between those two numbers as essentially
the trial court should have just split the difference?
I would not propose that a court should just split the difference. I think the precedent...
So then why was the trial court's ruling wrong?
Yes. So there was some interesting evidence and obviously lack of evidence that was presented. The specific finding by the trial court, it was 22, the factual finding. The trial court says in the written findings that they are going to value Fresnel Holdings at $8.324 million based on a 2019 tax return. And then finding of fact number 23, trial court says we can pin the valuation of the business assets to the date of separation, and they use that $8.324 million figure. That figure appears to come from Ms. Ravenet's Exhibit 32, which is the Vanitas Holdings LLC 2019 tax report. The issue with using that number is that both parties testified at trial, and for her, it's going to be the transcript at 187. For him, it's the transcript at 454. They only own 30% of that company at the time of separation. So after separation, he was trading shares of the company for more capital. Trial court says, I'm going to value it at the time of separation. Trial court obviously has the authority to make that determination, the time of valuation. Both of them are testifying, though, we owned 30% of Fresnel Holdings. The trial court's value, or the evidence that's presented, appears to be this spreadsheet, which is Exhibit 1, and they're using that exact same number. It's not clear that they were accounting for the percentage of the company that is actually owned by these parties, which is a significant overvaluation. Mr. Ravenet was testifying pretty consistently that, so this is going to be at the transcript 360 to 361 and 295. He's consistently telling the trial court the only value in this energy company is the equipment, and the equipment's worth $7 or $8 million. So they own, at the time of separation, 30% of this equipment, which is $7 or $8 million. I would submit to the court that 30% of that number would be a proper valuation. There would be substantial evidence to support that.
But that's only if the court believed what, I'm going to call them by their first names, Louis testified to with regard to the value. What the court said is, I have all of these numbers coming at you all, and I have some information, and based on looking at all of that and then listed it, this is what I'm going to value it at.
Yes.
Why can't the court do that?
I think the court can do that, but that number still has to be tied to something. There has to be some kind of evidence to support that number. If that number is tied to this specific exhibit 32, then it's not a correct valuation of what they owned.
But the court talked about more than just that exhibit.
Correct. I think that goes to, I think then we're talking about adverse inferences. So then we're talking about, his failure to respond to discovery, his failures to comply with LFR 10. Frankly, halfway through the trial, the court tells him, put all of your valuations into Exhibit 88, which winds up becoming the exhibit that is attached to the trial court's orders. And instead of doing that, he creates a completely different spreadsheet that includes a bunch of debts that have not been proven to the court. So I think certainly he made that a difficult proposition for the trial court. When we're looking at that, and I would agree with opposing counsel from their brief, that when we're talking about marital misconduct under 2609080, we are also talking about financial misconduct. So the court can consider, is he dissipating assets? Is he concealing assets from the court? I think the dilemma we run into there is that it's not, candidly, it's not clear that he's trying to conceal assets from the court. What the whole record looks like is they bought this energy company. They grossly miscalculated how much money was going to have to go into that. He starts leveraging other assets, the real estate, to put that money into the energy company. And when you look at the transcript 332, 334, 338, 370, what he's telling the trial court is, I need to be able to access that real estate to put money back into the energy company, and I'm trying to preserve the family investment in the gas company. I don't think it's entirely clear that he was intending to withhold information, that he was intending to dissipate assets, that he's intending to conceal assets or hide them.
Well, it may not be clear to you as his appellate counsel, but it seemed to be clear to the trial judge who had them in front of him for the trial and went through everything that happened with regard to his actions, not just with regard to that company, but with regard to other things.
And
So
I think,
how can we
yeah.
circle back, and you can answer when you
Thank
come
you.
back, and look at that again differently, because that's kind of not our job. And there was information in the record and in the testimony that does support the court doing what it did. So when you come back,
Thank
we
you.
can talk about that.
Good morning, Your Honors. Lucy Clifthorne here on behalf of Andrea Engelson, formerly Ravenet. I think the starting point for the court's review today really is the trial court's broad discretion in a dissolution proceeding. The trial court's decision is only reversed for a manifest abuse of discretion. So it is Mr. Ravenet's burden to show that there were untenable grounds or an untenable reason for its decision. And although they're not always delineated as findings of fact and conclusions of law, there are quite extensive findings and conclusions that the trial court did provide that we can look at.
Did the court sort of mix up information with regard to the companies and the timing when it was doing its valuation?
I think the trial court did its best. I think the trial court was very clear, at least in my view, in the findings and conclusions with regard to the fact that it was because of the discovery failures, the failure to provide information that was undisputably within Mr. Ravenet's control and not within Ms. Engelson's control. And that was why the trial court didn't have a complete picture of the events. There were several references in the appellant's brief that said, well, the trial court failed to take steps to find out. But as I've sat here this morning, I realize there are many things we ask of our trial judges, but one of them is not to become a private investigator. It was not on the trial judge to go out and find out what the value of this company was. The trial court is supposed to take the information presented and then make the best decision possible. And I think that's what the trial court did here.
Was there a percentage problem with the court's valuation, given that they owned 31%?
Yes, I don't think so. I think the trial court did acknowledge that in finding and conclusion number 5, where the court said that at the time of separation, the parties held a 31% share, and Fraenel formerly owned under Vanitas. So I think that was acknowledged, and even if you're looking at a 31% of the $8+ million valuation, you're still looking at the trial court making a decision on what is equitable based on the parties' evidence, the evidence presented by the parties and their testimony. I think that I think I've addressed that Mr. Ravenet's claim that the court failed to do a proper evaluation, which is not the case here. And I also wanted to point out that Mr. Ravenet takes very contrary positions in his testimony to the trial court, as well as in the appellate brief, where he says, on the one hand, I had to dissipate the marital assets because I was trying to save the family business. And that's why I had to spend all this money, as counsel also pointed out. But on the other hand, that is why this business is only worth $150,000. You can't say it's worth it for me to, encumber all of the existing assets of the marriage and spend all the money in our accounts when you're saying this is not an asset worth preserving. And the court said very clearly, I'm doing what I believe to be equitable here, where this person has had exclusive control over the energy business, this, liquid natural gas thing in Peru, and I'm going to give it all to him since he obviously believes it's worth this money. That is the equitable solution here. The wife doesn't want it. The husband does. We'll give it to the husband. So I think that the court, yes, did not have complete information, but did the best that he could with the information that was available. And really, it seems that the disagreement of the appellant here is this claim that, again, about that no special master was appointed, despite the fact that one was never requested. One of the several continuances that was given was specifically so that Mr. Ravenet could try to bring such a motion if he wanted to. And I think that the other claim that Mr. Ravenet makes is, well, this was a punishment. And he keeps coming back to this thing, well, I didn't have an obligation to accept service. So this is a punishment. But the trial court specifically cited its basis. It cited Henderson versus Tyrell at CP 556 and said, look, I'm allowed to make a negative, an inference based on the negative, I think it's called negatively productive conduct that causes the dissipation of marital assets, close quote. And I think what Mr. Ravenet is doing is conflating the misconduct with the consequences of his failure to comply with discovery. We all recognize you have to provide the evidence to the trial court because the trial court is not the private investigator in this case. The respondent says, well, the trial court never found that Mr. Ravenet intentionally concealed anything. But again, that's not quite true. If we look at several of the findings, 11, 17, 18, 21, but most particularly 37, where there is a direct connection made by the trial court that is, quote, where a party's bad acts permeate the entire proceedings, the court need not segregate which, this is with regard to the fees, were incurred as a result of intransigence and which were not. The husband's intransigence here was pervasive, both after separation and during the litigation. So the trial court used this intransigence and failure to provide discovery both to support the conclusions that it made with regard to the distribution of assets, but also to the award of fees, which was the last point to address this morning, although I don't know if that will be an issue that the court has questions about. Are there any specific questions that I can address?
Part of what Luis seems to be saying is that however equitable it appears the distribution was, ultimately Andrea got the income-producing property, and he got the property that was debt-riddled and not so income-producing, and that's what made it inequitable.
Right. Well, again, this is presumptively income-producing property. We can't bring in necessarily other cases that are in the public record to disprove that occurred after the trial. But what we can say is that each of the pieces of property that that Ms. Engelson was awarded was encumbered by debt, significant debt, and that some of that debt was incurred without her knowledge in the case of the beryllium note. That was, in fact, after a 4-year separation, what triggered, according to the record, the filing of the divorce proceedings, is the fact that she suddenly saw this property was being listed for sale, that she had no idea would be listed for sale. So I think that that it is incorrect to say that only Mr. Ravenet was saddled with anything that had debt. The debt involved in the energy business was not documented. The debt on the properties that were awarded to Ms. Engelson was documented in the trial court. So there was an equal allocation or an equitable allocation of the debt.
And also the intransigence attorney's fees, that was not appropriately given to her.
Right, and that's what I started to reference with finding and conclusion number 37, where the court specifically justified and explained that an award of fees could be based on intransigence and that here it was pervasive. And I think it is, again, worth noting that Mr. Ravenet never, the trial court in its 18 pages never referenced the failure to accept service. This was based solely on the intransigence of excluding the wife during the separation from access to the marital assets or even insight into the marital assets, as well as intransigence, and he called it recalcitrance, during the litigation, which was the failure to follow the trial court's orders. Anything else I can address?
Thank you.
Thank you. I believe with regard to the adverse inferences question, when we're talking about dissipation, the record as a whole is really indicative that this is a case of missing reasons. And sometimes that happens in family law. But you see that all of this has to do with Ms. Engelson saying, he shut off my internet access or access to my emails. I couldn't log into my financial accounts. He blocked me from the accounts. He says we had this big family disagreement, at her mother's house in Maryland, and then she stopped speaking with me. I couldn't get her to communicate about the business. And the trial court asks her in the transcript at 388 through 390, okay, there's a breakdown of communication. Communication is cut off. I can't consider any marital fault in the distribution, but it would help me to understand why, like what happened here. Because Ms. Engelson is saying this is him blocking me from accessing financial assets, financial resources, seeing into these businesses. And she tells the court pretty unequivocally, he knows why I could not communicate with him, our friends, or the investors. So something happens based on this disagreement where she just stops communicating or participating in communication with regards to the business. That answer is in the transcript at 388 through 390. Nobody ever answers that question for the trial court. It is an important question. So if we're saying he blocked all of her access to all of these financial accounts because he disabled her email, and she's saying, well, I wasn't communicating with him, but he knows why, there's an issue there, and it's not necessarily him blocking her out of financial accounts. Obviously, that does accumulate into something larger, which is a disagreement with regards to the assets. I think that also kind of leads into the issues in Urbana and Crescetto, which talk about, it's not just the statutory factors we're looking at, we're also looking at, is the property that we're dividing more attributable to the efforts of one spouse or the other? And this is a couple that created and sold software companies, real estate in Seattle. They had been extremely financially successful under this model in the marriage where he was kind of controlling the assets or making those decisions. I think that's where he's getting at with a lot of the things that he's telling the trial court, and clearly they weren't landing well. At 459 in the transcript, he says, I'm trying to make a decision. Do I keep moving forward with this energy company that's hemorrhaging money? I mean, I think obviously they are very upside down in that energy company. There's nothing there. Or do I sell it for essentially asset value? And he did not want to sell it for asset value. That's hard in terms of the negative inference because there are reasons there. And I think the court can review whether that's negatively productive conduct. Briefly, so quickly, with regards to the attorney's fees, I think the specific argument was with regard to the amount. It's made at the end of the transcript. So the evidence showed that she had already withdrawn $100,000 from the Fresnel bank account and indicated that was going to attorney's fees. And then there was also an award of $68,000 in attorney's fees. And I think the issue would be a double award there. Thank you.
Thank you for the arguments today. We are in recess.